right. Hello again. This has been Hitchcock Cross talking to you today. It's been a hell of a week. I can tell you that. Let's just go right in order. Debbie Kuether, the motion dismissed that MPS filed against Debbie Kuether is done. I think we can say we got what we wanted, and we are moving right along. It's Debbie Kuether versus Keith Posley et al. Calvin Furman is a named party, and that Catrice Cotton is a named party. These are names for MPS users, and many board members as well. So that is that's a positive step. Let me put it like that. Discovery is now open to Dr. Kuether, and she can now issue subpoenas. So good luck to everybody. Is I guess my feeling on that one. Number two, I would say we'll do this in slightly reverse order. A judge poo-pooed the channel here. Which is good and bad. And on the one hand, it's not the biggest channel there ever was, and on the other hand, it's not the smallest either. Though, to wrap it all off, number three here is the Mike Meyer case, and this is one that I'm particularly proud of. If you will recall, Mr. Meier is a lawyer, non-practicing attorney, one of the most dangerous of the species, and a 20-year board member, been the president on and off, but never, I guess, has he had a situation like this where, and basically I want to be clear, when he originally came to me, the issue was that the attorneys were giving the board members advice basically to break the public records law. And there was a scandal, and we'll call this the Avid scandal, and we don't need to get that big into it, but there was a scandal. Because of the scandal, reporters asked for public records. Mr. Meier gave out some public records. I don't remember the details of it, and went and told the other board members, hey, don't forget, you've got your own personal voicemails. You got to give those to the reporter too. And there was some, we'll say, criticism for Mr. Meier overproducing, and that was the word that they used, overproduction, which in my mind, I think you should probably, that in itself is, I don't want to get carried away and say something like criminal, but it's outrageous. The very notion of overproducing a public record is, it just makes my blood boil even to hear that word, but okay. So then they kicked him off a committee, and they did a few other things. They also had discussions. Now remember, in Wisconsin, the business is supposed to be kept in the open, and all discussions are supposed to be public. Well, they created a public document, that a Google document that they were discussing the people's business on. Mr. Meier refused to participate on it, and they wouldn't let him speak. They had another incident where they were talking about human growth and development. And I think that the most fascinating part about the human growth and development, if you don't know out there, is another word for sex education. Of course, they're going to change it. You've heard me say many times that educators, every 10 years need to change the vocabulary words for the same topics. And because each new generation of PhDs needs to think like they've invented something. It's perfectly fair. I mean, management does that all the time too. It's not new, it's not unique, but you got to keep up. Advertising loves to do that as well. Absolutely no doubt about it. Synergy. So, okay, so they, this human growth and development, they got a survey, and they put out a request for information to the public, and the public was not limited to the residents or even school people that were connected to the school. So the board didn't like the outcome. The majority of the board didn't like the outcome, and there was that allegation that they had manipulated the data so as to improve their outcome that would back what they were planning on voting for all along. Now, key thing in there is that the there is, because we had those documents, we've read them here. The superintendent is told by, the president of the school board and others basically tell the superintendent to change the data, and the superintendent then tells the rest of the public and the other board members, not the members of the faction, that it was his idea. And I think all of those stand for the proposition there that you got to conduct business in open, and you can't retaliate against public officials when they do that. When they say hey, I'm standing up for the law. Now, Mr. Myers did one other thing. He went on the radio because a set of parents came to him and told him that there was a secret no suspension policy. And I've heard of this all over the country, all over the states. There's a big concept called proportionality or disproportionality. And what that means is that in almost any school district you can name, that whatever the local minority is, they are disproportionately represented in special education. And that does represent a couple of different things. One thing it represents is the use of special education in lieu of other disciplinary practices. It is well documented, whether people like to believe it or not, that minorities in any given situation, the most classic one studied, of course, is African Americans in white settings, are going to be perceived as more naughty than their counterpart white students. And that's going to be so by white educators, black educators, doesn't matter who it is, it's going to be across the board with authority figures. I think we see that with policing, we see that in all sorts of realms. That's the explicit way that many people say that is the criminalization of, and I don't want to just limit it to black people, although I think that is oftentimes, certainly here in Milwaukee, that is what we're talking about. No doubt. But it's certainly not limited, and in your area of the universe, it's going to be something else. So, I guess I should widen this out, but I would like to know what are, let's just take New Zealand and Australia. I would be very interested to know, too, from listeners, what is the criminalized minority in your area? Because there's going to be one. I think it's, in my experience anyway, there always is. So, okay. We are 8 minutes in, and I'm still just talking about my week, and I haven't even gotten my son off to camp yet. But hey, that's how we go. We are going to get into the Baker Tilly report, and maybe we'll just do an update here. This is how we go. So, Mr. Meier appears on the radio, and this is the Dan O'Donnell radio show for those in the area who know. Apparently, it's a bigger deal. He calls in. I don't know. I'm not a big AM radio consumer. One thing I will say about AM radio has always been like 20 years behind everything. It's just always been the case in their technologies. But I've been to a lot local because of local concerns, and it's so amazing to me how their websites still look like it's 2005. And, sometimes you go in grocery stores and you seem like you're going in the back and past, but this was like website. It just cracks me up. Okay. So he goes on the radio, and what happens? They straight up file employee complaints against him. Other board members do. And if I remember correctly, I think it was Jennifer Willis. It could have been board member Hoag, Hoag, I think. I don't have their identities at my fingertips as much as I have, for example, the MPS people. But I know the votes. So they actually had an investigator. It was Shayna Lewis, but that didn't work out for them. So then they paid Jeff Lacey, same attorney, same law firm. As far as I know, and I'm always shaky on this, I believe it was about $40,000 that they paid this Jeff Lacey to investigate my client, Mike Meyer. And I believe they probably paid Mr. Meier and he did similar sum because they investigated him, but I don't know. It's so hard to tell when you have a settlement there. But the headline here is $132,500, which is mostly representing the fees that it cost to get me to protect his and enforce his First Amendment rights as an official. But they investigated, they paid an attorney, and again, I don't even know because what he had done because, first we couldn't even get the complaint in written form against him, and they wouldn't send us this, and they wouldn't send us that, and they weren't investigating Mr. Meier's allegations. They were just saying whether or not what he said fit with the stated policy, not with the reality. Again, there was just, we could say that this investigation was problematic on its face, even if it wasn't in retaliation for him exercising his First Amendment rights. He had a right as a politician to go on the radio. And this is something that Wisconsin school board members across the state need to understand. You have First Amendment rights. You may have fiduciary responsibility to the board and to the district. But that doesn't mean that you're not an elected public official and that you lose your First Amendment rights to stand up and speak out and be whistleblowers. Because even if you're in the minority or even in the majority, you may find yourself in a situation where you think that the school board is doing something illegal. And this case, in my opinion, stands for the proposition that the government and the Constitution gives school board members and other local public officials the right, and I would even say the duty, to speak out on behalf to the public and alert the public to things that are going on. And if they are retaliated against for talking about politics, that is a violation of that person's First Amendment rights. And the Constitution, the federal courts are open to enforcing that right. So I think that is, I know there was a Supreme Court decision, thank you, Steve Lato, that came out talking about very similar issues. This is somebody getting arrested, and we will talk about that more too. That's what we do. But I think that is, that was a particularly amazing thing. I'm going to add one more thing about this. We won, just in terms of positionality and understanding sort of the process. I think there were 5 counts, something like that, 4 or 5 counts that were up. There may have been, let's focus on 3 of them. I think that is the best to say. But 4 and 5 were out for some technical reasons, and we're focusing on 1, 2, and 3. The process there that happened was summary judgment, okay? And as you know, I'm mostly talking about summary judgment as something that the employer is filing against the employee in federal court, that I'm defending against, and I'm saying, no, judge, there really is a dispute, a material dispute here about facts, not the law, but the facts, that we need a jury, a fact finder to resolve, okay? Well, it's the fact that either side, and this is way more common in a public record situation, open meeting situation, that either side can move for summary judgment. And in fact, what happened is both sides moved for summary judgment simultaneously, okay? So what the judge had in front of him, this is a circuit court judge in Milwaukee County, not a federal judge, because it's the state open meetings law, just the simplest way to put it. That judge had to go through their motions for summary judgment, why all 3 of the counts should be dismissed and the case should be closed out because there's nothing to dispute, and our 3 motions for summary judgment, we should just win the case. There should be no trial of any kind, and this should be done and it should be a question of what are our damages. Okay? So how did that go? And the judge did in very torturous fashion, really white knuckler. He went through all of their things first, 1, 2, and 3, and denied them all. I think it's possibly he dismissed 4 and 5 at that time, which was not a large deal as far as I understood because they were still live. Okay. Then he went through ours first, second, and third. He denied, meaning he said that there was issues of fact enough for the first issue, whether or not there was a meeting behind closed doors, in which they told my client that he had overproduced and couldn't do things like that, meaning that's the public business and how to respond to public records, and they have to discuss that in public unless it's a noticed session, okay? Closed session. So for that reason there was a question about, was there a discussion or wasn't there not a discussion? So we were going to have a hearing, a trial, on whether or not there was a discussion, okay? First rule. Second one was there a secret meeting of this policy committee that they kicked my client off this policy committee because he had, he had stood up for the public records for production. And as you know, as retaliation, okay? You did this, well, you're not on this committee anymore, which is, let's be very clear on this one. Elected public officials can be removed from committees all the time for any reason or no reason at all, except for an illegal reason. Does it sound familiar? Okay. So you can kick somebody off a policy committee because you don't like their shirt, you don't like their politics, you don't like whatever they say. But you can't do it and politics is a free, being a political opponent of somebody is an absolutely legitimate reason to not want them to be on a particular committee, okay? It kind of sounds like free speech, doesn't it? That's not the same thing, okay? And here's why. To say, and there's a very important distinction, to say that somebody has a right to say something. I've got a free speech right to say something, okay, is not the same thing as saying that I have the right to stand up and be a Republican or a Democrat, okay? Or to say that there aren't consequences for being a Republican or a Democrat in a political arena, okay? To put it another way, a Republican who has the power to appoint offices when these are political positions, it's perfectly legitimate to say, I only want Democrats to do this, or I only want the Democrats who brought in the most money or have the most votes or whatever. And so because you're not one of those, you can go and do that, okay? It's different when you say somebody went on and spoke on the radio against the district, so then therefore I'm going to punish them, okay? It's different when you say, you politician told us that we need to stand up for follow the law, and therefore I'm going to kick you off this committee, okay? That's the distinction there, okay? Not because I think I can clarify what's giving me the problem. Every action that somebody could take, according to Aristotle, can be defined as a political action, right? It's the question of what is and very often when you say speech, anything can be free speech, and it's the question of what is a legitimate reaction to that speech and what is protected speech. And the category of I feel a politician could easily, and where this is, I studied this for quite some time, and I guess this is a more difficult line to explain than I thought, but the line there between what is I am a school board member, I am aware that these guys are committing something wrong, or I believe that they're violating the rule. Hey, public, you need to know about it, okay? That is an act of free speech, as what I'm saying. And I think, guess what I'm going to do? I'm going to say I'm not clear, and I'd like to think about it more. That's my lawyer response on that. So here we are. I'm going to wrap that up with one short little story here, which is that my son, I dropped him off to camp. Boy, if you knew him, he looks exactly like me when I was that age. The bus is the same. The location that they pick up the bus is the same. It really could be the early 90s, really early 90s. It's quite amusing. Of course, and this also could be the same. But here's the difference, is that 8 o'clock the night before, he says that I don't really have any wool socks. And I don't know where you live, but in my mind, having wool socks, I first thing I ever saved all my money. I mean, and I distinctly remember building my original wool sock collection. You know, $10 gifts here there because being a camper, you don't really have an income, and certainly you're not spending all your money on wool socks. I remember the first time I cleared out a Cabela's back when they had all those 90% merino socks. I remember wool socks is something that I support. Let's put it like that. But I'm also remember going through that young man's packing list quite a few times. But nothing, I have to tell you, gives me greater happiness than to drive out to Main Street in Menominee Falls, local joke if you get it, and to go get a bunch of, 72% wool socks, because anything else would be outrageous. But yeah. Stick with us. We'll keep you informed. My dad had a concert this week, and he opened with my younger brother's theme song. And by the time because the jazz, he got the jazz. And when it came, he did not have time to play the Deliberate Indifference theme. So we don't have a new recording yet, but I'm sure there will be. Take care. We'll keep you informed.